Welcome to the Virginia Division of Child Support Enforcement. To better understand intergovernmental cases, DCSC created an overview of what an intergovernmental child support case is and what you can expect when your child support case needs a second child support agency to help your family. This video will talk about what an intergovernmental case is and give you answers to some common questions about how these cases work and how long the process takes. Questions like, what is an intergovernmental child support case? What happens first? What are my responsibilities? We are here to help. How long will this take? What if I don't receive the child support? If you are looking for an answer to a specific question, check the description below for a link that is part of the video. We will also share our contact information if you have any questions. Let's get started. What is an intergovernmental child support case? An intergovernmental child support case is opened when the family members do not live in the same state, territory, or tribal land, and one state or direct actions are not producing results. This means two or more child support agencies work together to establish, modify, and/or enforce child support orders for families in those situations. Your case may start out as an intergovernmental case, or it may become one when one of the parents moves out of Virginia. The Virginia Child Support Agency, or DCSC, is the same agency that provides service for families that reside in Virginia and will handle the intergovernmental cases too. If you are unsure if your case is intergovernmental, just ask your caseworker. Every situation is different. Let's go over some common terms. UIFSA, which stands for Uniform Interstate Family Support Act. This is the law the child support agency must use when two states are working together. Most intergovernmental cases are called UIFSA cases. The parent or party who receives support. The parent with primary custody of the child, also called the obligee or previously custodial parent. Parent who owes support. The parent who does not have primary custody of the child and may be ordered to pay child support to the custodial parent, also called the obligor or previously non-custodial parent. Initiating jurisdiction. The child support agency that sends an intergovernmental case to the other jurisdiction to work the case. It may be a state, territory, or tribe. Responding jurisdiction. The child support agency that receives the intergovernmental case from the initiating jurisdiction. The responding jurisdiction uses their laws to establish orders and their procedures to enforce orders. It may be a state, territory, or tribe. Referral. The packet of information and forms that the initiating jurisdiction sends to the responding jurisdiction to open the intergovernmental case. Petitioner. The parent who starts the intergovernmental case in the initiating jurisdiction. Respondent, the parent who lives in the responding jurisdiction. Registering a foreign order. This is a legal action. If the responding jurisdiction is asked to modify or enforce an existing order from a different state or tribe, the responding jurisdiction may need to register it in their own court so that the court has the power to modify or enforce the order as if it were an order the responding jurisdiction entered. Arrearage, the amount of court-ordered child support that was not paid, sometimes called back child support, unpaid support, or past due support. So, when you find out your case is an intergovernmental case, what happens first? The answer depends on what kind of case you have. There are three major types of intergovernmental cases: parentage and/or establishment, review and adjustment or modification, and enforcement. Let's look at each of these types of cases. Paternity means establishing legal parents. Another term you might hear to describe this is establishing parentage. If the parents were not married at the time the child was born, no one signed the acknowledgement of parentage, or the court did not enter an order to establish parentage. Parentage may need to be established, or in other words, the court needs to enter an order saying who the father or the second parent is. The mother that gave birth is considered a legal parent unless parental rights have been terminated. If parentage needs to be established in an intergovernmental case, the mother will need to fill out forms from the child support agency before the case can be sent to the responding jurisdiction. The responding jurisdiction needs your information about you, your children, the other parent, and your signature on these forms before they can get a new order. The responding jurisdiction will not take your case without them. The Virginia DCSC will provide those forms. The responding jurisdiction may require genetic or DNA testing to prove parentage. An appointment will be set up for the mother, father, and child or children to get tested in the city or near the town where each lives. Even if the mother is not available for testing, as long as the father and the child are tested, the genetic test can still determine biological parentage for the courts. If the mother is not available, there may be another person taking care of the child, like an aunt, uncle, or grandparent. Child support can still establish parentage, but it is very important that your Virginia child support worker knows those special circumstances so the proper action can be taken. After parentage is legally established, the court can order child support to be paid. Establishment cases are cases where a new order of child support needs to be set. Establishment of a child support order is usually done at the same time parentage is legally established, but it can be done later too. Orders may be entered against mothers or fathers. Once parentage is legally established, the court or administrative agency of the responding jurisdiction will use the financial information of the family to figure out the correct amount of child support according to the laws and rules of the responding jurisdiction. There are intergovernmental forms that are very important for establishment cases, and there may be more documents that you will need to provide, like your paycheck stubs and proof of the cost of medical insurance and daycare expenses for the child. If you already have an order, but it has been at least 3 years since child support was figured, or there's been a change in the parent's incomes or in the expenses for the child, one or both parents may want the child support amount to be recalculated. This process is called a review and adjustment or a modification. If the parents do not live in the same jurisdiction, sometimes Virginia can still review the case for a modification, but sometimes an intergovernmental case may be needed to modify the case. DCSC needs to know in which jurisdiction the last order was entered, where the parents live now, and which parent is requesting the review before they know whether Virginia can do the modification or if an intergovernmental case is needed. If an intergovernmental case is needed, the parent who wants the review will need to fill out forms from DCSC and provide financial information like paycheck stubs and proof of expenses for medical insurance and daycare for the child before the case can be sent to the responding jurisdiction. Did you know child support agencies help both mothers and fathers start the review process and modify child support orders? After the review, the monthly child support may go up, go down, or not change. The last kind of case is an enforcement case. If the parent who owes support is not paying as ordered and lives in a different jurisdiction, DCSC may send the case to the jurisdiction where that parent lives or is receiving benefits. Usually, there are no forms for the parent or party who receives support to sign. If the parent who owes support is paying child support directly to the family and it is not going through the child support agency, the parents must tell the child support worker about the child support payments, including the date they were paid, how they were paid, and the amount of support that was paid. When the parent who owes support is ordered to pay child support through the child support agency, but support is paid directly to the family, it will cause problems for proving how much was paid and how much is still due. Child support should be paid as ordered. You may wonder what your responsibilities are for your child support case. If you are the respondent, here's how you can help your intergovernmental case be as successful as possible. Provide all the requested information to your caseworker, respond to any requests for information, and return documents on or before the deadline. Update your child support agency with changes in your contact information, family, or financial situation. If you are the petitioner, here's how you can help your intergovernmental case be as successful as possible. Provide all the requested information to your DCSC caseworker. Send in your special forms, information, and documents on or before the deadline. They do not have to be notarized, and you do not need to hire an attorney to represent you. Update your child support agency with changes in your contact information, family, or financial situation. This includes if your child goes into foster care, lives with someone else, or if you have a new baby born. Once the paperwork is filled out correctly and completely, DCSC will get that process started as soon as possible and help the responding jurisdiction to get working on your case without having to request more information. If the information or the special forms are not correct in the opinion of the responding jurisdiction, then the DCSC caseworker will have to keep working with you to get it right, which may slow down the process. Here's some good news for the petitioners. You will not have to travel to the court hearing in the responding jurisdiction. Under UIFSA, the responding jurisdiction's court cannot force you to appear in person. Your DCSC caseworker will notify you if the responding jurisdiction is requesting that you testify. Also, if you want to be present, you should tell your DCSC caseworker when you return the forms. To participate, the responding jurisdiction will set up a special telephone call or virtual meeting, and you can appear from home, work, or your local child support office. You may wonder who does the work on intergovernmental cases. The answer is both jurisdictions work intergovernmental cases. When Virginia is the initiating jurisdiction, the DCSC child support worker in Virginia will help you the most. Even when the case is an intergovernmental case, Virginia DCSC keeps helping you. This agency prepares the intergovernmental referral and sends it to the responding jurisdiction, answers your questions about the case, monitors the case to make sure the responding jurisdiction receives the paperwork and assigns it to an office. The DCSC caseworker will work with the caseworker in the responding jurisdiction to make sure they have everything they need to go forward with your case. Your caseworker will contact the responding jurisdiction for updates and pass that information to you. You will also receive copies of all important documents your caseworker receives, including the new order. The Virginia Child Support Agency will send you the child support when it's paid on your case. Talk to your caseworker about direct deposit options. Also, the responding jurisdiction is helping you by filing your action in their jurisdiction and handling your case like they do their own cases. The responding jurisdiction will use their jurisdiction's laws and formula for calculating child support. It may be very different than what would have been ordered if the case were filed in Virginia. For parentage and new support orders, the other jurisdiction's laws govern that order for everything, including at what age the child is no longer eligible to receive support. However, for a modification, the other jurisdiction's laws do not modify everything. Mainly, they modify the amount of support and the payment date. The jurisdiction laws in your first order still control what age the child is no longer eligible to receive support. The Child Support Agency and the responding jurisdiction will work and communicate with your Virginia DCSC child support caseworker to get orders entered and child support payments made. If you are the respondent, you should always contact your child support worker in your state. If you call Virginia directly, we will tell you to call your in-state caseworker. If you are a petitioner, you should always contact your child support worker here in Virginia with your questions. If the responding jurisdiction contacts you and wants information so they can figure out the child support amount, or if they want you to appear at court, please contact your caseworker here. If the responding jurisdiction sends you a letter or the order, please call your caseworker in Virginia to make sure everyone has the same information. If you call the responding jurisdiction, they should tell you to call your Virginia DCSE caseworker. How long will this take? These cases are more complicated, and more than one child support agency is involved. It's still the best way to get the child support you need when the parents do not live in the same jurisdiction and the state is not able to work directly with the other parent. Some reasons for the extra time are that the referral packets require special documents that can be hard to get, and the referral has to go to at least 2 offices before a caseworker there can start working the case. If you need to get an order established, there are several factors that affect how long it takes. In both parentage and modification cases, the paperwork will have to be served on the other parent, and you will have to go get on the court calendar or the docket. Depending upon the other parent and the size of the caseload in the courts, both kinds of actions could take a while, just like if you were going to court in Virginia. The big reasons to remember are if the other parent does not cooperate, or if the responding jurisdiction must take it to court, it could affect the timeline. If the responding jurisdiction uses administrative process, meaning they do not need judges or courts to enter orders, your case may go more quickly. In parentage cases, if the court orders genetic testing, the normal range is 6 to 18 months to get a parentage and support order after the referral is sent. For modification cases, the normal range is 6 to 12 months to get a modification order after the referral is sent. With a new order, the responding jurisdiction will start enforcing the order, and if the other parent is working, payment should start pretty quickly. If the parent who owes support is paying, you should receive the child support on your card within 4 days after it's paid in the responding jurisdiction. It will get forwarded to Virginia's agency, and both states will make a record of the payments due and received. At least once a year, Virginia will get the payment accounting records from the responding jurisdiction and make sure all payments have been given credit in both jurisdictions and that the balances match. What if I don't get the child support? Both states can be working to enforce the order. Initiating jurisdiction. As the initiating jurisdiction, Virginia DCSE will keep working your case. DCSE will monitor the case to find employment or other income for the parent who owes support, and either take actions to get the payment started again or ask the responding jurisdiction to enforce the order there. The responding jurisdiction. If the initiating jurisdiction requests assistance from the responding jurisdiction to enforce your case, the responding jurisdiction will monitor your case for employment or income for the obligor parent and will send income withholding orders to the employer to pay the child support. However, in intergovernmental cases, if the parent who owes support is not cooperating, many times the case must go to court in the responding jurisdiction to take one or both of these legal actions. Registration of a foreign order and/or civil contempt before the responding jurisdiction can get the child support coming in for you. The legal actions could take several months before the other parent appears before the judge. Success depends upon the parent who owes support's ability and willingness to pay. We hope this video gave you lots of useful information. If you still have questions, please visit our website at dss.virginia.gov/family/DCSC for more information about child support cases and the Virginia Child Support Program. You also may call toll-free to 1-800-468-8894 Monday through Friday from 7 a.m. to 6 p.m. to update your contact or case information or leave a message for your child support worker, or email DCSC at askdcsc@dss.virginia.gov. Please stay in contact with the Virginia Child Support Agency so we can work together to make the best decisions for your child support case. Thank you.